specifically in paragraph 30, where Justice Mugweng says in the judgment that a policy passed by the minister cannot simply be ignored. If the minister wishes to change the policy, it is open to the minister to change the policy. But as far as the policy remains, the policy should be complied with. There have to be good reasons to disregard the binding nature of government policy. So, in this particular instance, the policy flows from the department. It has been endorsed by the minister. We've alleged that it continues to operate. And it specifically regulates the subject matter that we are dealing with here. And we see that the conduct of the government is insisting on an interpretation that simply enables them to take a decision regardless of the consent and regardless of the majority views of the people in the area, is not in fact consistent with its own policy. And just to complete the point, we've dealt with this at paragraph 237, 238, 239, and up to 251 of our founding affidavit. And the government responds to it in paragraph 85 at page 134. So I would submit in this regard that not only do we find a proper cause of action in the terms of imperial, we also find a cause of action in international law, but we also find a local cause of action in the policy adopted by the government, and in the fact that the government, for no reasons at all, because the government could have taken the view that we know what the policy is, but for the following rational reasons, we've decided to disregard it. In a case where it is clear what the policy is, and it is clear that there has been a breach of the policy, one would expect at a bare minimum that the government would plead facts that would satisfy the test of rationality. On the facts of this particular case, the particular policy adopted by the government should not be adopted. What is not acceptable is for the government patently to disregard a policy that has been communicated publicly, because as the opponent says, this is a policy on the website of the department. One would expect that a policy communicated publicly, which communities are entitled to expect to be complied with, if it is not to be complied with, at the bare minimum, there must be a rational basis, and it must be set out in the affidavits of the government. And here, what we are criticizing the government for is disregarding its policy without any basis that is pleaded on the facts. And this is what we say in the founding affidavit, paragraphs 236 to 251. Could I then move to the last cause of action, which is the customary law. The entry point to customary law is, of course, the Constitution, and particularly the provisions in section 211 and 212, which is under chapter 12 dealing with traditional leaders. In section 211 sub 3, it's provided that the courts must apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. So two comments should be made about this provision. The first is that it imposes an obligation to the court to apply customary law where it is applicable. But secondly, it makes it subject to any legislation that specifically deals with customary law. So customary law would then find expression both through the terms of the pillar, because it is a legislation that specifically deals with customary law. But it would not make it subject to the MPRDA, because the MPRDA is not one of the statutes that are envisaged in section 2113, because it is not a statute that specifically deals with customary law. So that is the starting point. But customary law also has foundations in the Bill of Rights itself, because in section 30 and section 31, section 30 specifically provides everyone has a right to use the language and to participate in the cultural life of their choice. But no one exercising these rights may do so in a manner inconsistent with the provisions of the Bill of Rights. And section 31 deals with cultural, religious, and linguistic communities. Persons belonging to a cultural, religious, or linguistic community may not be denied the right with other members of that community to enjoy their culture, practice their religion, and to use their language, to form, join, and maintain cultural, religious, and linguistic associations in other organs of society. Now, both of those rights bear specific resonances here, because we have shown how mining will break apart the cohesive nature of the cultural linkages. One example is the dislocation from people's graves. The fact that the founding affidavit expressly explains what the impact will be of the fact that they will now be dislocated, there will be no connection with the current world and the world of the past. This is a most serious invasion of the right to practice one's culture. And if that invasion is to be countenanced, it must be countenanced in probably the most clear circumstances, legislatively mandated, where the restrictions in the Bill of Rights can be clearly demarcated and should comply with section 36 of the Constitution. This type of invasion cannot be imported by way of implication, which the government seems to contend. It's implied in the NPRDA. It is the type of invasion that would warrant specific legislative decisions under section 36 of the Constitution to say that we are specifically limiting the rights to culture, we are specifically limiting the rights to religion that are contained in section 30 and 31. So the constitutional foundation of the importation of customary norms is to be found in section 21111, in section 30, and in section 31 of the Constitution. It plays two roles. The one is a foundational role, which is an instrument of interpretation. When one reads the NPRDA, one should do so in a manner that is respectful of people's cultural identities. But it also serves another purpose, which is it is a substantive right that can only be limited by way of a law of general application. But it is a law that must specifically limit the right, not by implication. So what is then this custom that we are dealing with? We began by illustrating the customs of the Pondo people in relation to the usage of the land and the allocation of the land. What we could see from the founding affidavit, supported by Professor Baynard's affidavit, is a multi-layered system of land allocation, land usage, and deprivations of land, which are respectful of individual rights within that community. In fact, if one can have regard to what is stated in the founding affidavit, one will see that how this community deals with questions of custom. Paragraph 104 and 105, most crucial to this aspect, at page 35. Paragraph 104, in customary law relating to land, the notion of some overall benefit for the wider community is simply not an adequate ground to deprive a significant number of community members of their rights in and to their land, What is important is full and informed consent. Also important is the need to avoid conflict and division. Our customary law places a special premium on social harmony and sound communal relations. Decisions which are likely to cause conflict are treated with the greatest degree of circumspection. The greater the likelihood of conflict, the greater the need for consensus in decision-making processes, despite any supposed economic benefits stemming from those decisions. A decision to approve mining operations without consensus having been achieved would trigger massive conflict between those community members who may benefit and those who would be severely prejudiced and harmed. It would tear the community apart. This is why, even if a majority of residents favored mining which is denied, this would not be a sufficient ground to consent to mining on our land under our customary law. Paragraph 106. This does, of course, not mean that it is not possible to approve mining on community land. If those community members would be negatively impacted by, the proposed mining activities, were guaranteed compensation that they accepted as sufficient to make up for the harm and loss and inconvenience that they were suffering. If mining were permitted and were therefore willing to be displaced and resettled elsewhere, and other members of the community who are not directly affected supported, then it may well be possible to secure the necessary consensus to permit mining. It would be necessary, of course, that any agreement was made on detailed and accurate information regarding the mining's impact, and that the provisions for compensation and relocation were definitely secure. So we see how the actual process works on a customary level. This is not an unreasonable stance intended to frustrate the alleged development. What is at issue is, we know from page 91, is that the entire way of living is about to be disrupted on a massive scale. What is at issue is that those who are affected should have an opportunity to consent to the decision that will be made impacting on them. And they make the point clear that it is not enough to go to a meeting and the majority votes on a particular aspect. If a decision has an impact of tearing the community apart, even the majority would likely not support the decision because of the cultural linkages that exist and the cultural bonds that bind these communities together. But at the same time, which illustrates why this is not an unreasonable rejection of mining, it is possible that the government as well as the mining company can make appropriate guarantees around compensation, around access to graves, around the restoration of the cultural life that is about to be disrupted. If those guarantees are made, they make it explicitly clear that there is no reason why we cannot consent to the mining operation, which also explains why this, in fact, is not an attempt at stultifying the ability of the government to transform or exploit minerals. It is simply a point about the critical significance of self-determination which the government itself has recognized. These allegations, which speak to the nature of the customary law of the Polo people, are again not meaningfully dealt with by the government. If one has regard to its answering affidavit, specifically at page 1431, paragraph 60, these are not fully answered at all. And if one has regard also to the expert affidavit of Professor Mteke, that starts at page 1451, right up to 1459. He again does not deal with the living customary law. And in fact, as I pointed out, at paragraph 7 of his affidavit, he seems, at least implicitly, to acknowledge the necessity of consent and consensus and conciliation as the pillars of customary decision making. So we would suggest to your leadership that the approach of the government that insists on approving mineral rights, mining rights in section 23, without the consent of the community is also in breach of Section 31, Section 30, Section 2113 of the Constitution, because it is a violation of customary law. Customary law is no longer the ugly-step system. It now has clear constitutional foundation. We've referred to the judgments of Shiluban, of Alexco, which illustrate why customary law is in fact central to the framing of the Bill of Rights. Of course, an argument has been made by reference to the Maxine judgment that the effect of the PILRA was the expunging of common law rights and indigenous rights. And that, of course, is clearly distinguishable here, because this is not a case about a claim by my clients to the minerals. My clients do not claim entitlement to the minerals. My clients claim entitlement to the land. Say the way in which their land is to be utilized can only take place, legally speaking, with their participation and consent. So those are the four grounds on which we contend we are entitled to the declarators. The most important declarators, we'll see. In paragraph 1, 2, 3, 4, 5, 6, and 7. And there are essentially three types of declarators. The first is a declarator relating to the rights of the minister under section 23 and 22 of the APRDA. The second is declarators relating to the application of the PILRA. And the third is declarations relating to customary law itself. The final argument, which is an alternative argument, relates to whether we are entitled to compensation before the Section 23 right is concerned. That will be made by Mr. Spoor.
I have the privilege of making the applicant's submissions on the alternative relief. So if the court is not with us on the community's right to say no to mining, we're looking for a declaratory relief to effect is set out in paragraph 9 of the notice of motion. Which in effect says that the minister may not grant a mining right over the land unless or until compensation, the nature and amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a competent court or through arbitration. Alternatively, that mining may not commence, that the mining company who's been awarded a mining right may not go onto the land until compensation has been agreed or determined. We will be submitting that to the extent that that entitlement to have compensation determined before mining commences is not provided for and cannot be read into the NPRDA, then to that extent the NPRDA is unconstitutional. And to that effect we filed a notice in terms of Rule 16A, notifying the respondents to the court of our intention to do so. That said, my lady, I'm convinced, and I'll be submitting that it is possible and quite consistent with the law to read that requirement that compensation should be determined in advance before mining into the NPRDA. So, why are we concerned about this issue of compensation? Well, Without this relief, the events are going to unfold in a certain way. Assuming that the mining right is granted when this moratorium comes to an end, the mining right is issued to the company, and then the company is entitled to exercise the rights that go along with the award of the mining right. And in terms of Section 5 of the Act, the holder of such a right may go onto the land to which such right relates together with his employees and bring onto that land any plant or machinery or equipment and build and construct and lay down for any surface, underground or undersea infrastructure which may be required for the purpose of mining, as the case may be, and then to mine for his own account on or under that land for the mineral in respect of which he is granted a right. His right goes further. Subject to the provisions of the National Water Act, the mining company is then entitled to use any water from any natural spring, lake, river or stream situated on or flowing through that land, or from any excavation or sink a well or a borehole, and to use that water for the purposes of mining activities, and to cap it all, to carry out any incidental activities to his mining operations, which would include roads and fences and gates and the like. Now, the disruption that is contemplated here is very significant. The mining area is a 22-kilometre stretch of land along the coastline, approximately 1.5 kilometres wide. And mainly it comprises ancient and less ancient sand dunes. And the intention of the mine is to mine those sand dunes along this 22-kilometre stretch of land. It will be open cast mining. They're not going to dig a shaft and go underneath. They are literally going to crawl across the landscape and devour these dunes, extract the minerals, and regurgitate them at the back end. The impact for the community will be significant. They've been alluded to by the learned counsel in this matter, and they're set out in some detail in the papers at page 48 to 51 of the founding affidavit, and also in the report of Mr. Michael Kuhn at page 1086 of the record. Essentially, the community is going to be displaced from their grazing land, where their cattle graze. That grazing will be consumed. They will be displaced from their ploughing lands. Those are the lands where they grow crops and food, beans, pumpkins, maize, to sustain themselves. They will also be displaced from their homes. As your ladyship has heard, there are approximately 75 families living in this area, of whom 68 have joined these proceedings. Some 600 people, of whom 300 approximately are children, will either lose their homes or find their homes located in and amongst this extremely disruptive mining activity. Their water resources are likely to be depleted and damaged, which the mine is entitled to do. And as council has alluded to, there will be enormous social and economic harm. The linkages between this community, cultural, social, economic linkages that sustain this community, will be disrupted and destroyed. In short, they are going to suffer loss or damage, as is contemplated in the Act. What is extraordinary about this mining rights application, and the previous one which was awarded, is that nowhere in that application, and nowhere in any other documentation provided by the mine or the government, anywhere in this record, you will not find a reference to what is going to happen as a result of this massive disruption. How are they going to live? Where will they grow their food? To the extent that people must be displaced, where are they going to be moved to? Bizana, Mthatha, Port St. John's? What's going to happen to them? Where are they going to live? How are they going to make an existence? None of that, my lady, not a single detail has been provided in advance of this mining application. We are completely in the dark about what is going to happen to us and how this is going to be dealt with. I just want to stop there for a moment, my lady. I use the word compensation, and typically people assume compensation means cash or money, but it doesn't just mean that. Compensation means something much wider than that. It means how will we be resettled? How will livelihoods be restored? Where will we live? Those are all aspects of compensation. It's not simply, when I'm saying compensation, I don't simply mean how much money. I mean, where, how are we going to live? How are we going to survive through this? And how are our lives going to be restored? Well, lady, the allegation that there is no provision in any of the mining, in the mining application and associated documentation about what will happen to this community, that averment is made at page 51 of the founding affidavit, at paragraph 1, 5, 7, and 8, where this is alleged, and in the responses from government and the mining company, that is not placed in dispute. So there's no dispute here that there is no provision that has been made about how people will be enabled to cope with this disruption. It is so that there were attempts, as required under the Act, to consult with the community. In fact, this dispute has been going on for a very long time, and while we might disagree about the content of the consultation and its adequacy or not, there has been a consultation process. But that consultation process has not had a good outcome. There is no agreement. In fact, there is very strong opposition from the community to the mining. They have said, we don't want it, we don't need it, we do not agree to it, we are opposed to it. Certainly, that pertains to the community living in the area to be mined. Further away from the mining industry, people who are not directly affected, but who may benefit in terms of jobs or other economic ways, are not so opposed. But for this community, under the leadership of the first applicant, the opposition is close to unanimous. They have said they will not move. Now, that creates an environment, a context that is ripe for conflict. We have a situation where a mining right might be awarded shortly. The mining company will be entitled to come onto the land. The community is implacably opposed, hostile to this. They say they're going to defend their land. There is a real risk of violence and conflict if there are no appropriate measures put in place to deal with the community's concerns about how their lives are going to be impacted by mining. So then I turn to the legal framework. Well, what does the law say about this? I mean, surely the NPRDA must make some provision about what's going to happen when a mine comes into a community who takes their land. Surely there must be something that says how you must treat with this community, how you rehouse them, where you rehouse them, what the standards are, norms. Is there something like that? Well, I'm afraid not. There is a policy void. There is a legislative void, a complete vacuum as to how you engage and how you address the concerns and the problems that this community is going to be confronted with. Now, the reason for that is historical. And principally, these issues about compensation never arise, certainly not on privately owned land. Because what happens is the mining company either leases the property or buys the property outright from the owner. The owner takes the money for his land and he moves to another town, another place, and he resettles himself and his family and his children there very happily. So these kinds of disputes that we're dealing with now seldom come to court. They only really arise in community contexts. They only really arise in this kind of environment. Because it's not so easy approaching a community and saying, let's do a deal. It's not a case of just buying their land. We cannot have a situation, well, the mining, quite frankly, would be unthinkable if the mine had to come along and say to this community, good news, we're going to buy your 22-kilometre stretch of coastline, 1.5 kilometres inland. We're going to give you a bucket full of money, and you will go and live somewhere else. That doesn't work with rural indigenous communities living the way that our clients live. You can't just give them the money and they will go away. So the idea in the NPRDA is that in the consultative process, the party should try and reach some kind of agreement, but although that's not express, it just says consult and address their concerns and engage, and I think Penguin Yama gives that consultation process some content. But really the issue about compensation is dealt with in section 54 of the NPRDA. It's a curious section, because the way in which it is drafted is from the perspective of the mining rights holder. So it says if the mining rights holder finds that the owner or the occupiers of the land in respect of which he's got a mining right is placing unreasonable demands in return for access to the land, or refuses to allow him access to the land, then he must notify the regional manager of the Department of Mineral Resources, which would be the regional manager for the Eastern Cape. And the regional manager must then call upon the community in this case and ask them why they are refusing to give access, to make representations regarding the issues raised by the holder of the mining right. And then he must inform the owner or occupier of the rights of the holder of a right. And then he must set out the provisions of the Act which the owner or occupier is contravening, which is curious because it's not clear what provisions those might be. So we'll come back to that just now. And inform the owner or the occupier of the steps which may be taken if he or she persists in contravening the provisions. Again, it's not entirely clear what is being alluded to here, because the question about whether an owner who refuses the rights to a mining company is contravening some provision of the law is, and I'll park this for the moment, in some dispute. However, if the regional manager, having heard the landowner or the occupiers, concludes, if he comes to the conclusion that the owner or occupier has suffered or is likely to suffer loss or damage, then he must request the parties to endeavour to reach an agreement for the payment of compensation for loss or damage. So we have a situation here where first you award the right, then, and I forgot to mention this earlier, in terms of section 5 big A, he must give 21 days notice of his intention to go onto the land. And then after the 21 days, he can move on to the land. And if he's resisted, he must notify the regional manager, who must ask the other side why they're resisting. And if he's satisfied that they're resisting because they're going to suffer harm or loss, he must then say to them, guys, sit down together and have a chat and see if you can resolve it. Now, clearly, considering that this process comes 12 years along the line, that seems a little late in the day for the DMR to insist that the parties try and find each other. Then it says in section 54, if the parties fail to reach agreement, compensation must be determined by arbitration in accordance with the Arbitration Act or by a competent court. Now, that phrase seems to be taken directly from the Expropriation Act, which contains a very similar provision. And then we have you begin that process by way of summons, by action, conceptually by application, although there are bound to be disputes. You issue a summons and you say we want compensation, and then you would litigate around that to a conclusion. Now, that, considering the nature of the harm that we're talking about, is bound to be a very long and complex and difficult litigation. How do you compensate people for the loss of their world, their way of living, a way of life that they've sustained for generations? How do you compensate people for being displaced, who knows, into a township somewhere, away from the coast, where you fish, where you live? How do you quantify these kinds of loss, harm? Whatever the answer to that is, which I don't know, it is going to be long, prolix, difficult litigation. And the community, you ask yourself, well, how on earth is an impoverished rural community supposed to sustain that kind of litigation? How are they supposed to litigate for compensation after the fact? Now, that may be very well if the mining process was suspended while we litigate around their harm and loss and the compensation they're going to get, which, I reiterate, includes questions about where we're going to live, how we're going to live, and how you're going to restore our livelihoods. Well, the Section 54 is not particularly helpful there. Section 54, subsection 6 says, if the parties can't reach an agreement between themselves, and he decides that this is due to the fault of the holder of the mining right, he may, in writing, prohibit the holder from commencing or continuing with prospecting. Now, quite frankly, this is a complex and difficult dispute, and the notion of fault with respect is misplaced here. There's a mining company who's obviously willing to make some tenders and some, make some contribution towards compensation and restoring livelihoods, as he's obliged to do. There is an obligation to compensate. It's also a no-fault obligation. But the scope for legitimate bona fide disagreement between the parties about the scope of that compensation and what it entails is huge. So a failure to reach agreement on compensation before you give up entirely and go to arbitration is unlikely to be caused by the fault of any party. It's more likely to be caused by the failure to reach agreement on some very difficult, complex issues. In those circumstances only may the regional manager block the execution of the mining right. Absent that, the mining right goes into effect, and while we're negotiating and while we're litigating around damages and compensation, while that process continues, the mining continues as well. And now, that is the continuation of the mining while this problem of compensation hasn't been resolved by agreement or by the court, is severely problematic. And there are a couple of reasons why it is problematic. The first is, of course, people's livelihoods are being destroyed as the mining continues. Huge machines, huge tracts of land are being stripped, bare, excavated and mined. People are suffering damages from day one, and they're not being compensated until we have an agreement or some outcome. Also, we're in a negotiating position here. So before we rush to arbitration or we rush to the court for a determination, the parties are sitting around the table and negotiating around fair compensation. But as those negotiations are taking place, the world of this community is being destroyed around it. If they reach an agreement, for example, they may be moved to a new house. If there's no agreement, they're not going to be moved. So we may find ourselves in a scenario that has been sketched in some detail by John Capel in the Benchmarks Foundation report, where people find their lands being taken and destroyed, their homes placed right in proximity of the mines, cracked and falling apart, people in the community leaving, abandoning their homes, running away. They might find themselves very, very quickly in a completely intolerable situation where they literally cannot hold themselves together. That is not a fair negotiation. That is a coerced negotiation. That is not free. That is negotiation under duress. If the mining company is mining at me and moving towards my home and destroying my lands in a progressive way, I'm not in a position to negotiate compensation on any fair or equal basis. That is a coerced negotiation, and that would not be tolerable. A short aside, it seems clear that as the law stands today, and absent your determination, that a mining right, the holder of a mining right, is entitled to go onto the land. And there are not many decisions on this issue. There have been a number of attempts to interdict mining pending agreement for compensation. But the only reported decision I've found is the matter of Joubert and others versus Miranda Mining Company Pty Limited. It's case number 296/08, 2009 decision reported at ZASCA at page 68, where the court said at paragraph 13, and this had application to a mining permit, not a mining right, but the principles are the same. Clearly, in terms of the section 22(7)(a), the holder of a mining permit has a right to enter the land in respect of which the mining rights have been granted for the purpose of exploiting its rights. The right to enter the land solidifies, in my view, once the mining permit holder has complied with the provisions regarding notification and consultation with the owner of the land or occupier and or other parties affected by the permit. So it does appear as if it's far clear the way the legislation is written, that by virtue of their rights under Section 5, they're entitled to go onto the land. We're arguing differently. We're arguing against that contention. We are relying very heavily on the city of Tshwane Metro case. It is in the authorities, I think, somewhere. But it's a constitutional court decision City of Tshwane Metropolitan Municipality versus Link Africa and others. 2015 bracket 6 SA 440 CC Constitutional Court. Now that dealt with a very similar piece of legislation, the Electronic Communications Act, in terms of which people are given licenses to roll out telecoms infrastructure, fiber optic networks across the country. And as your ladyship will appreciate, this is a developmental priority. It's a really important issue, perhaps more important than mining, that companies can roll out infrastructure and ensure that society benefits from this new technology and the opportunities that brings. And that act includes a provision very similar to what is contained in the MPRDA. Section 22 of that act says a license holder, proper term is an electronic communications network service licensee, may enter upon any land, including any street, road, footpath, or land reserved for public purposes, any railway and waterway of the Republic, and construct and maintain an electronic communications network or electronic communications facilities upon, under, over, along, or across any land, including any street, road, footpath, or land reserved for public purposes, any railway and waterway of the Republic, and alter or remove its electronic communications network or electronic communications facilities, and may for that purpose attach wires, stays, or any kind of support to any building or other structure. So essentially, if you're a license holder, you're entitled to go onto land and build your towers, transformer stations, dishes, erect them, whatever you wish, and you do not require the permission of the landowner. Now, that law is slightly less draconian than the MPRDA, in the sense that Section 22 also says that in taking any action in terms of subsection 1, that's the power to go onto the land, due regard must be had to applicable law and environmental policy of the Republic. The wording of Section 5 of the MPRDA doesn't include such a qualification. It just says, subject to the provisions of this Act. There is no reference to any other law. So it's slightly less draconian. Our argument here is going to be that Section 5 of the MPRDA, read with the provisions of Section 54, those qualified limited protections relating to compensation, that constitutes an arbitrary deprivation of property and contravenes the provisions of Section 25(1) of the Constitution, which protects us against the arbitrary deprivation of property, unless this court follows the direction of the Constitutional Court in the Tshwane matter and holds that this right to go onto the land is qualified by the requirement that compensation must be agreed or determined in advance. The Tshwane matter is extremely helpful in terms of the reasoning that we urge this court to follow. It sets out, first of all, in lucid, clear terms that I can't compete with, what Section 25(1) means, and if I may. Section 25(1), the learned justices said in the minority judgment of Jafta and Chiki at paragraph 58, Section 25(1) guarantees protection against deprivation, which constitutes a substantial interference or limitation that goes beyond the normal restrictions on property use or enjoyment found in open and democratic society. It's, with respect, fairly clear that the loss of your way of life, the loss of your community, the loss of your ancestral land, does constitute a fairly substantial interference or limitation, and I think one would be hard-pressed to suggest that it's a normal restriction that we should be entitled to bear with. Now, deprivation is, of course, not sufficient. This is clearly a deprivation. But our argument here is it's arbitrary. So what does that mean? Well, again, referring to the Tshwane decision, deprivation in itself is not sufficient for interference to fall foul of Section 25(1) of the Constitution. It must also be arbitrary. And that's where my focus is going to lie in these few minutes. Ackerman J, and they reference a case, FNB case in that article, concluded that a deprivation will be arbitrary if the law, referred to in Section 25(1), does not provide sufficient reason for the particular deprivation in question or is procedurally unfair. It thus follows that for the applicants to ground successful challenges to, in this case, these particular sections, they will have to show that the impugned provisions are either procedurally unfair or that insufficient reason is preferred for the deprivation in question. In other words, it is substantively arbitrary. Now, does the profit of a mining company like TEM, was until recently a foreign-owned company, does their private commercial interest in mining titanium along this stretch of coastline, is that sufficient reason to deprive an entire community of their history, their culture, their way of life? That's a substantive question that the court will have to answer in light of all the facts that have been presented here. But what about procedural fairness? Lady, I referred to the kind of the qualification that we're going to be met with, or the defense we're going to be met with by the government and the mining company, is they're going to say, look, you can appeal to the regional manager and he will make a decision. Now, as I've already indicated, his power to make a decision is very limited. It pertains to fault, which is extremely narrow in the context of such complex disputes. But administrative justice, procedurally fair administrative justice, forbids decision makers from making these fundamental decisions. So at paragraph 72 of the Tshwane judgment, the court cited with approval the principle. It says, every person who undertakes to administer justice, whether he is a legal official or is only for the occasion engaged in the work of deciding the rights of others, is disqualified if he has a bias which interferes with his impartiality, or if there are circumstances affecting him that might reasonably create a suspicion that he is not impartial. The impartiality after which the courts strain may often in practice be unrealized without detection, but the idea cannot be abandoned without irreparable injury to the standard hitherto applied in the administration of justice. Now, the regional manager is the most senior manager of the DMR in the province. He reports directly to the Director General and the Minister.
But the regional manager only comes in after mining operations have started. As I understand the release, sort of, correct me if I'm wrong, I understand the release sort of 39 is that the issue of compensation must be decided even before the mining right over the land has been granted. Am I correct?
There are two. They're in the alternative as well, my lady.
I understand that.
Okay, so the first would pertain, perhaps let me just address that first, the first one, about this should be determined.
Sorry to interrupt you. The reason why I'm asking this is that if you look at section 54, it clearly provides for compensation only once mining has started. Or am I correct? Only once the hold is prevented from accessing the property, am I correct?
Only once the right has been granted.
Yeah. Now, the relief that has been sought, on what basis can that be read into the present Act? The Act as it stands, section 54, because it's clearly what is different from what is currently provided for by the Act.
There are two alternatives. So we do. The first is that the right should not be awarded before this issue is resolved. Now, there is a strong argument for that. The section is a 27, am I right? When considering the award of a mining right, which is done by the minister, there are a limited number of factors that the minister must have regard to. Most of them are financial and have to do with the efficiency of the mining operations. But they do include the applicant has access to financial resources and has the technical ability to conduct the proposed mining operation optimally. That is section 23(1)(b). C, the financing plan, which is how they're going to raise money and use that money, the cash flow effectively of the operation. If the financing plan is compatible with the intended mining operations. And then D, if the mining will not result in unacceptable pollution, ecological degradation or damage to the environment, and an environmental authorization is issued. It's difficult to imagine how the minister is going to decide whether the money is adequate and whether there will be unacceptable pollution, ecological degradation or damage to the environment, assuming people are part of the environment and assuming people's living environment is also under this rubric of environment, and it doesn't just relate to birds and fishes. How does he do that if he doesn't know what compensation will cost?
But surely the legislature would have included in section 23 a requirement that a mining right will not be awarded unless or until a suitable amount of compensation has been agreed with the community. Now, my point of concern is what the applicants are asking this court to do is to fundamentally alter the discretion that the minister has in terms of section 23. Isn't that so?
My lady, I'm going to make this little argument about this. I'm suggesting that the minister, that it's implicit in this that the minister should require that compensation be determined in advance, because that question also impacts on the viability of the mining operations. So we have moving people and resettling people is a really expensive business if it's done to standard. Now, we've got a whole mining plan and a whole mining budget, but if there's no agreement on one of the biggest cost components, which is land and the cost, how do we know that the company has the means to do this? 22 kilometers of coast, wild coast, some of the most beautiful coastline in the country, extending 1.5 kilometers inland. What does that cost? If you were to buy that, not for mining, where you get it free, but if you were to buy that for yourself, what would you pay for that? Tens of billions of rands. Now, obviously the mine doesn't intend to pay tens of billions of rands in compensation, because then their entire operation would be non-economic. They need to get hold of that land and demolish it for free, or as cheaply as possible. But that quantification hasn't been done. So if the court were to find that clearly compensation needs to be determined in advance, but I don't wish to be prescriptive about whether it should be at the level of the decision of the minister, I suggest it doesn't make any sense for him to ignore it, and I suggest it should be read in there, that it includes an obligation on him to satisfy himself that compensation is agreed, that it's fair, that it's affordable, the mine can pay it, but it can just as well hold till after the award of the mining right. So the mining right is awarded, but if your ladyship were to find, if the court were to find that mining can't begin until the compensation issue is settled, from our perspective as the affected community, it doesn't make an enormous amount of difference. But what we do say is that, my lady, the award of the right is the deprivation. I think it's strike law that the award of a right over your land constitutes the deprivation. So that would be arbitrary if the minister authorises that deprivation without having considered the issue of compensation. The implementation of that right is also constitutes a deprivation, and that deprivation that flows from the execution of that right would also be arbitrary if there's no provision. So I don't have a strong view on where the court should intervene. Should it be at the level of reading this requirement to determine compensation in section 23, or should it be in section 54? I don't have a strong view on that matter. I made the point, my lady, about administrative justice and procedural fairness. There is a provision in the NPRDA that actually is on the system side and stipulates it. I think it is section 6 of the NPRDA, my lady, which says that subject to the Promotion of Administrative Justice Act, any administrative process conducted or decision taken in terms of this act must be conducted or taken as the case may be within a reasonable time and in accordance with the principle of lawfulness, reasonableness, and procedural fairness. That opens the door to a finding by this court that it would be consistent with the principles of administrative justice that before awarding a license, in this instance, certainly, perhaps generally, the minister should have regard to the issue of compensation. Compensation should have been settled and determined in advance. And of course, section 6 also assists the court if it wishes to read in such a requirement in section 54. We're not looking for a ruling of unconstitutionality here. We're looking for the court to come to our assistance and read this requirement that compensation be determined either into section 23 or in section 54. A lady, the Chwane judgment gives us gives the court a lot of comfort that if it were to read this requirement in, it would not be doing anything radically new or different. And Justices Cameron and Froneman deal at some length with the law, the common law, as it relates to servitudes, and makes a persuasive analogy in the context of the Electronic Communications Act that these kinds of rights that are afforded mining companies are akin to servitudes. In fact, I think the definition of a mining right in the Act is it is a real right and in the nature of a servitude. It's a limited real right, as is a servitude. and the judges deal with this question of the exercise of those rights. So they make a couple of really important points. The one made at paragraph 142 is that he says about section 22 in this Communications Act, he says that right is similar to a general servitude. It allows the dominant owner to select the essential incidental rights of the premises and to take access to them as needed for the exercise of the servitude. But the right is not unrestricted. The dominant servitude holder cannot just barge in. A large part of the argument of behalf of the City of Tshwane, the judges say, was premised on the outrageous notion of the licensee just barging in, brazenly disregarding municipal protections and duties and works. That can never be. It is alien to our law's conception of rights over another property. As stated in Holman, exercise of servitude is subject to the important condition that incidental rights must be exercised civiliter. The Constitutional Court has embraced the principle that rights over the property of another must be exercised civiliter modo. What does it mean, the judges ask? Well, the law tells us civiliter modo is to be bound up with the facts. And that there's ample flexibility in the common law to do it. And here is the crux. What the court concludes in relation to this right under Section 22 of the Communications Act, which give people the right to just go onto property, but not to barge in, he reads with the common law on servitudes, he reads that the court concludes as follows. He says, from this it appears that the following general principles apply to our common law of servitudes, which he suggests is analogous with 22, which we are arguing and submitting are analogous with Section 53. The rights 54. Servitudes, mining rights is what I mean. Sorry. Servitudes may not be enforced on landowners, except in the case of way of necessity. Enforcement of a way of necessity may only be done through the courts. Compensation in proportion to the advantage gained by the plaintiff and the disadvantages suffered by the defendant is payable when this happens. Payable when this happens. The holder of the right of a general servitude may select the essential ingredients he wishes to exercise, like the premises needed or the access required. This selection must be exercised in a civil or reasonable manner. I point out that we have no knowledge of how this mining company is going to exercise its rights here. Whose houses, whose fields, whose lands will be the first to go? We don't know. That is not civility. As things stand right now, the right's going to be awarded, 21 days notice, and they will just barge in. And then we're at the mercy of the regional manager. Where changed circumstances require it, the common law, and this is with respect to the license that is awarded to this court, where changed circumstances require, the common law of servitudes must be adapted to arrive at a solution that is just to the parties and does not prejudice them. In the case of enforced servitudes, this must be done in a manner that least inconveniences the servient owner. Well, lady, the judges then go on to confirm the rights of the holder of this network license, including his servitude over the land. Says the servitude, the exercise of the same must be done in a civil and reasonable manner, which requires notice, which is provided for the Act, and detail about where they will be locating their works and access. Critically, at paragraph 152C, compensation in proportion to the advantage gained by the network licensee and the disadvantages suffered by the owner is payable in respect of the exercise of the public servitudes section 22(1) grants. And where disputes arise about the manner of exercising the rights under section 22 or the extent of the compensation payable, these must be determined by way of dispute resolution to the extent that it is possible or by way of adjudication. Access to the property in the absence of resolution will be unlawful. decision can be very, very closely aligned to the facts of this matter. The implications of what we're asking this court to do are not over the top, they're not eccentric. The relief that we're seeking, which is the declaratory relief on the part of the court to confirm that compensation must be determined in advance, agreed or determined by the court, is not going to frustrate mining. If the parties cannot agree on mining, on the terms of this compensation, the matter can be referred to a court. The court will adjudicate the matter, without arbitration if required, and a just and fair decision will be made. A ruling to this effect will compel mining companies, like the respondents in this matter, to do a proper cost-benefit analysis before they launch on one of these exercises. Assess what is the cost going to be to the community. Can we afford to pay that cost? Because we know we're not going to get away with it. There's a court that's going to give oversight. It's going to allow for the law to be developed around compensation. I've alluded to the complex nature of this determination, about culture and tradition and rights and ways of life and how those will be compensated. It will allow the courts to consider these things in a thoughtful way and to balance the interests of the economy and the country and people who are going to get jobs in the mines with the rights and the interests of the people whose rights are affected. It will contribute very substantially to sustainability and stability around mining. We've seen from the reports of Mr. John Capel the appalling consequences of ill-considered, rash, barge-in type mining, where the consequences and the harm that people will suffer has not been adequately taken into account. And critically, a ruling to this effect is going to bring in legal, judicial oversight over this process and address what is a very, very serious problem that has caused great harm to the people of this country and could potentially cause a great deal more harm if it pleases the